Session of our study circle. This evening, we delve into a highly relevant and crucial topic, that is Tamil Nadu bills, judicial activism or judicial overreach. This subject holds significant importance to all of us, and I am confident that it will spark a lively and insightful discussion. We are incredibly honored to have with us a distinguished guest, Advocate Sanal Kumar sir, who will enlighten us on various facets of this topic. Sir's profound experience is well known, and he has authored numerous articles and is actively involved in socially relevant initiatives. Furthermore, he was recently designated as Senior Advocate by the High Court of Kerala, a testament to his exceptional legal prowess. On behalf of the Bharatiya Abhibhashan Parishad, I extend a warm welcome to Sanal Kumar sir, and we eagerly anticipate his insights. Once again, welcoming all of you to the session.
My dear friends, I'm really scared when I see the faces before me, because many people who are sitting before me, I think that they are more learned than me, and what else there remains for me to enlighten you people, because you might have come across, you might have read all these matters which now we are going to take as the subject matter of discussion. I think that it's a privilege for me for being invited for this function, and first of all, on the outset itself, I express my sincere gratitude to the office bearers of this association, Bharatiya Abhibhashan Parishad. In fact, the subject upon which I am supposed to make some points for your discussion is gaining momentum nowadays because of the presidential reference. Now we have seen through the President of India, Draupadi Murmu. This is in the context of the decision declared by the apex or top courts in the Tamil Nadu bill case, which was placed before the Supreme Court for its adjudication. But there was a delay complained by the state government regarding the bills which were sent for the assent to the governor. It is so said that about 18 bills, 12 or 18 bills were pending before the governor without any decision thereon taken by the governor, which prompted the government of Tamil Nadu to file a writ petition under Article 32 of the Constitution of India, very rare move, for getting a declaration that the president or the governor concerned must be given some directions under Article 142 of the Constitution for taking a decision within a time frame. So that decision was placed before a bench comprising of 2 judges, which ultimately was decided by the Supreme Court, which is now causing a big hue and cry in the socio-political and legal circuits. Actually, before we going into these issues, we have to see the constitutional history or the adjudication by the Supreme Court after the commencement of the Constitution regarding the constitutional aspects which touches upon 2 gray areas or two new concepts or coinage which we have evolved on adjudication, that is judicial activism and the judicial outreach. Actually, when I heard about the judicial activism and judicial outreach, I could not find any distinction between this overreach and judicial overreach and judicial activism. I thought that these 2 things are one and the same. But that was in the initial days of my career and also when I was studying in the law college. But later we could understand that when going through the various decisions of the Supreme Court which are discussed, I could understand the difference between the judicial activism and the judicial overreach. My understanding is, I would like to share with you people that judicial activism is something that is permissible within the bounds of the constitution. The laws are silent, but there is still a law which affords some grey areas for interpretation. And the citizen is in need of redressal of his grievance. The court undertakes the exercise of adjudication of the issue by expanding the scope by interpretation of the provisions. We have seen many instances in the past. In the history of India, in the judicial history of India, we have seen so many cases wherein the Supreme Court has undertaken this exercise for the purpose of rendering justice to the parties by undertaking this interpretation process. So that is something that is permissible within the bounds of the constitution. But judicial overreach is something that is different and which is an anathema. I would say that it's an anathema to the constitutional democracy itself. Judicial overreach is something where the judiciary undertakes an exercise which is overstepping the renowned principle of separation of powers, which is expounded by, Montesquieu. In his Spirit of Law, he is expatiating upon this concept of separation of powers. There are three wings for the state. State is actually the Bharanakulam which we say. That is not the state that we understand in the ordinary parlance, not the state. But the state means Bharanakulam, as is defined under Article 12 of the Constitution. It has three links. The executive, which is expected to make laws. Then the judiciary, that is expected to interpret laws. Then the executive, that is for the of laws. So there are defined barriers, defined territories for each organ to function. When all these organs are functioning in sync, then we see that there is perfect constitutional democracy. In all other cases, there is no perfect constitutional democracy. Nowadays, we have been witnessing various instances where the Supreme Court is undertaking where we actually see some sort of an overstepping and is encroaching upon the territories assigned for the executive to do certain things or for the legislature to do certain things. The latest incident is something that is pertaining to this present Tamil Nadu bill case. But before we go through these nuances or legal nuances of the adjudication which the Supreme Court has undertaken in the Tamil Nadu case, we should go for a survey of the development of this judicial overreach, which started with judicial activism. So there are 3 points which you have to bear in mind: judicial activism, judicial adventurism, judicial overreach. Then the foremost one is judicial restraint. See, we all know the Constitution of India has come into force on the 26th January 1950. But many people would say, I also understood that the Constitution has come into force on the 26th day of November 1914, in which we we celebrate 26th of November as the Constitution Day. Well, that is the day on which the Constitution was adopted by the people of India. But actually, the Constitution has come into force on the 26th day of January 1950. From where do we get this? But from where do we get this? The date of commencement of the Constitution. There is a specific article in the Constitution itself, not unlike in the statutes. When you take a statute, you will see that this act will come into force and so on, or this act will come into force on the date notified by the president or the governor. But very curiously we see this is towards the end of the ending portion of the Constitution, you will see the date of commencement of the Constitution. I think that it is Article 393 of the Constitution. 393 or 394, I'm not sure 393 or 394, because it clearly says that 26th day of November, 26th January 1950 shall be taken as the date of commencement of the Constitution. It is not that the Constitution has come into force on 26th November 1949. It has come into force on 26th January 1950. Except certain provisions like citizenship, then election, all other provisions will come into force on, had come into force on 26th of January 1950. And that Article 393 specifically declares that when you take the date of commencement of the Constitution, the date of commencement of the Constitution is 26th January 1950. What I wanted to say is that after the commencement, just I contextually refer to the Article 393 of the Constitution because there are a lot of doubts which were also in my mind as to whether this, but what is actually the date of commencement of the Constitution. Anyway, now we are treading on the development or evolution of this concept of judicial activism. Judicial activism, with the decisions of the Supreme Court, it started. I think that it's not, there are the initial trends in the judiciary was that the government led by the Congress party, most of them, the members of the cabinet and most of the parliamentarians were also of, which were belonging to the independence struggle. When that government was leading reforms, it actually wanted to have the support from the judiciary. Fortunately, the judiciary was supporting the reforms which were brought in by the Nehru government and various state governments. The constitution had come into force, which ensured the right to property as a fundamental right. Right to property was a fundamental right, as you all know, in the initial step. But later it was by 42nd Amendment, 44th Amendment, it was taken from that part 3rd, and now it is Article 300, it is only a constitutional right. So when there was a fundamental right to property, various semindari laws came into force. Semindari laws came into force, which were assigned before the Supreme Court. And semindari laws were set aside as of right to property, as is mentioned under part 3rd of the Constitution. So that prompted the government of India to bring in first Constitution Amendment. First Constitution Amendment was necessitated because of the decisions of the Constitutional Court setting aside various Land Reforms Act. So by the first amendment to the Constitution, Schedule 9 of the Constitution was incorporated. Apart from that, Article 31A and 31B were also incorporated in the Constitution for protecting tenancy laws. From when these laws were challenged in first Shangari Prasad versus Women of India, I would say with all acceleration that the Supreme Court supported the legislative measures or constitutional amendment introduced passed by the Parliament of India. The parliamentary supremacy, it's very important then, because that is the only place where we could see in the evolution of this judicial activism and judicial overreach, where parliamentary supremacy was upheld. The Constitution bench decided that Parliament has every power to amend the Constitution. That was in Shangari Prasad case. Later, again this trend started in Shangari Prasad in Sajjan Singh case. Also, the dictum that was laid down in Shangari Prasad was followed. But with the Golaknath case, you all know the Golaknath case. With the Golaknath case, the 11 judges bench, by a split verdict, 6-5, declared that the constitutional amendment is a law that is defined under Article 13(2) of the Constitution, and any law, including a constitutional amendment which should deprive or which should abridge the fundamental rights, will fall foul of the Constitution. That is I.C. Golaknath case. So you can see the departure from toeing the lines of the government. Judiciary is taking a deviation from the path. It has got its own nexus with the political developments which were taking place. You see, when Shankari Prasad case was decided, Pandit Nehru was the president. There was no dissent or dissension. Congress party was going with its own full majority, and it was having all the I would say that the full authority was exercised by Pandit Nehru in all matters, and even including the appointment of judges. And I would say that with some reluctance, with the hesitation, I would say that the judiciary was to some extent reined in by under the leadership of Pandit Nehru. With the death of Nehru, the Congress party underwent some sort of a dissent, and the dissent was evolving, and the political spectrum, especially the executive, was becoming frail. When the executive was becoming frail, we will see something is the judiciary has started exercising its supremacy. Then for the first time in Sajjan Singh case, this basic structure theory was formulated. Secondly, then comes the I.C. Golaknath case. What was decided in 1967? Congress party was almost split with the Organization Congress and the Congress that is led by Indira Gandhi. So there was actually, we have to relate the judicial supremacy exerted or judicial overreach with the political developments which were taking place. The political developments which were taking place in 1967 was marked with the Congress party's split. Mrs. Gandhi was actually losing her upper hand in the administration with the Congress party, with the other faction led by Neelam Sanjeev Reddy. I think Neelam Sanjeev Reddy was gaining some control. So when the executive, what I wanted to say is when the executive becomes weak, then the judiciary starts exercising its supremacy. So this was going on. After that, you all know the Keshavananda Bharati case. Then comes the Keshavananda Bharati case that was decided in 1973. But in 1973, when Keshavananda Bharati case was decided, Supreme Court said that okay, the parliamentary supremacies, the sovereignty of the parliament is approved, but with the rider that you can't touch the basic features of the constitution. But at the same time, I think that the logic which I have now put that when the judiciary becomes, when the executive becomes weak, the judiciary is gaining prominence. That is to some extent, we can't say this. That proposition may not be applicable or cannot be applied with its full force in the Keshavananda Bharati case. Because when Keshavananda Bharati case was decided in 1973, we see that Indira Gandhi was emerging as a very powerful leader after the 1971 Bangladesh war. But still, this basic structure doctrine, when it evolved in Keshavananda Bharati case, with a wafer thin majority, I would say that it is 7-6. So that basic structure theory is presently being used or wielded by the judiciary as a weapon for evolving formulas or issuing directions or setting aside parliamentary legislations, which in a way is amounting to overreach. It cannot be said that it's a judicial activism. So when we take the decisions or the major adjudications which the Supreme Court had undertaken thereafter, also we see that there is a trend that was developing to arrogate to itself the power even after 1990. So I will say that in 1977, 1973, when this decision was rendered, Keshavananda Bharati case was decided, this basic structure doctrine came into force, and with that started exercising its powers or exerting its influence upon the decisions of the executive. Then the 1977 at the emergency that was over. Then after emergency 1980, Indira Gandhi came to power again with a thumping majority, that is 354 seats. Indira Gandhi. It is at that point the SP Gupta case came. SP Gupta case, you all know the judges transfer case. Who is having primacy in the matter of transfer of judges, which in turn also was applicable to the appointment of judges. The Supreme Court, on seeing the might of the executive, did not venture into a litigation where they could arrogate to themselves the powers of appointment and transfer of judges. They said that the primacy will always lie with the executive. So, when the executive was very supreme and when the executive was exercising its powers with the full confidence and support from the people, the judiciary was showing its restraint. It was not transgressing the limits or encroaching upon the boundaries that is set by the renowned principle of a separation of powers. That is in 1980. Then you see, after 1980, Indira Gandhi was murdered in 1984. From 1989 onwards, we see fractured verdicts. India was for the first time was seeing minority governments. In 1989, VP Singh government came. After the fall of VP Singh government, general elections were held. P.V. Narasimha Rao came. For the first time, minority government concept came into force in India. We started seeing what is minority government. In a minority government, all coalition partners are demanding their share. The government could not be run with all ease which a single party could do in the matter of administration of government. But with this phenomena that was developing in India, the judiciary slowly started again exercising its might over, I don't say that might, but exercising its powers in the name of judicial activism. One thing we should not forget, because after 1970s or in the late 70s, we were seeing a lot of positive judicial activism also. That is not overreach. Justice V.R. Krishnaiyer, Justice B.N. Bhagwati, they were developing the new concept of public interest litigations. Public interest litigations were developing in the late 70s. Where a person, if he is ignorant or illiterate and he doesn't have the means for approaching the court, a public spirited person acting pro bono publico can approach the court and raise the grievances and get the grievances redressed. That concept was something that was alien to the locus standi concept which we were nurturing for quite a long time. That was a revolution. And the liberal concept of locus standi, which is developed in the public interest litigations, are examples of the judicial activism which we have seen. The Sheila Bhatt's case, you know. Then Husainara Khatun's case. That is a case wherein a writ petition was brought on record with a letter that was received from the Supreme Court regarding the plight of prisoners, under trial prisoners. In the Husainara Khatun case, the right to speedy trial was held as a fundamental right under Article 21, which was later more expatiated in the decision P. Ramachandra Rao's case. So in those cases, that era we cannot forget, because that is the era where we would see judicial activism. Sheila Bhatt's case, which I have already mentioned, then Husainara Khatun case, and so many other Bhim Singh case, Then we also know one that is on the civic side, that's the Jolly George versus Bank of Kochi. A fantastic interpretation was given to Article 21 of the Constitution by the Supreme Court of India. The rights, the right of the litigants, ordinary citizens. The right, the off-quoted judgment is the Jolly George versus Bank of Kochi when we file cases against arrest warrants issued under Order 21 Rule 37 of the CPC. Very famous quote also was there, being a poor is not a crime. In a country like India where Daridra Narayans are living, being poor is not a crime. These were the statements or the very catchy words which we could get from these decisions. And so this period was actually marked by intense judicial activism for the benefit of the litigants. So this was actually interpretations of the sections or interpretations of various provisions of the Constitution for imparting justice to the parties within the bounds of separation of powers. We can't say that there is any overreach there, but within the bounds of the constitutional limits, the judiciary was exercising its function to the benefit of the poor, to the nation, etc. After that, from 1989, up to 1989 also we could see some decisions. I'm not able to recollect all those decisions, but that was also an area where we would see very robust judicial activism. But we see there is the judiciary on saying that the polity has become frail, the executive has become weakened. Slowly, whenever matters are coming before the Supreme Court or other constitutional courts, they start exercising powers where they were treading upon the areas which were earmarked for the executive to function or for the legislature to function. It was during 1993 when Narasimha Rao was in power. That is the minority government. When the minority government was in power, seeing the weakness of the minority government being run by Narasimha Rao, who was under pressure from various other constituents of the coalition, the administration could not be, except on the globalization, etc., front, administration could not be carried out, and the oversight of the government was not reaching to all areas. It is at that point of time the collegium system of appointment started evolving. In 1993, the Supreme Court Advocates on Record Supreme Court Advocates on Record Association case, the seeds of this collegium system was sown. From 1993, from the first case, that is Supreme Court Advocate Bar Association case, the Supreme Court started evolving this formula how to appoint judges, who all are the stakeholders in the appointment of judges. He has got the primacy and paramountcy over the appointment of judges. That is in 1993. Then you see, when you travel again down to 1998 to 1999, 1997 actually was a tremendous period for the Indian democracy. We had seen fractured verdicts. Governments after governments are coming. General elections were held for 3 times during a period of 3 years. Complete instability was prevailing there. Political instability was there. And adding to that, many of the leaders, tall leaders of various political parties like V.C. Shukla, L.K. Advani, all were in the dock following the Jain Hawala revelations. So not only the political parties, but of the political and also the executive became weak. At that point of time, when I am relating this to the point of time, you can assume what happens. The Supreme Court ultimately came out with the collegium system of appointment with its fullest colors. That was in 1998. After 1998. So what I wanted to say is that somehow you can relate it with the political happenings. When the judiciary is taking steps, or when we say that judiciary is overreaching, it is relatable to the frailty of the executive on the other side. So that factor which we have to take into account when we see the developments, constitutional developments relating to judicial overreach and judicial activism are deliberated. So after this 1998 event, you see that what is the importance of this decision? There is no provision in the constitution regarding the appointment, etc., except it has to originate from the executive, and there is a consultation with the Chief Justice of India. So, to that, certain things were added to. So, there is actually, in the name of interpretation, interpolations have happened, wherein a new system has come in place for appointment of judges. So, this you can see when the parameters of overreach and activism, judicial activism are taken. This can be doubted or dubbed as, I would say that for some I would say because I have to be very careful in using the words when we say or when we deliberate upon these issues of judicial activism and judicial overreach. So anyway, third decision of the Supreme Court on this. Thereafter, in 2014. In 2014 is also important. That 2014 is important for our constitutional history, for the reason that for the first time, the Parliament had passed a legislation, National Judicial Appointment Commission, and has brought in Constitution Amendment. That Constitution Amendment is a unique one in the sense that it was unanimously adopted, or more or less unanimously passed by the Indian Parliament, barring a single person raising objection, that is always he raised some objections. All parties joined together for passing National Judicial Commission Act and also the Constitution Amendment, which would give sanctity to this Judicial Commission Act, constitutional sanctity. So that was in 2014. But before that act came into force, this act coming into force, a writ petition was filed under Article 32 of the Constitution before the Supreme Court, saying that this is going to undermine the basic structure of the Constitution, in the sense that the independence of judiciary is going to be taken away. Very unusual assumption of jurisdiction. The Supreme Court heard the matter, and the 5 judges bench felt that this constitutional amendment is unconstitutional for the reason that this is offending the basic structure of the Constitution. Independence of judiciary is one of the basic structure of the one of the features, the basic features of the Constitution. So it has to be struck down, and it was struck down. So that was the most unfortunate event in the constitutional history of India, where the legislation which was passed by the majority, not majority, unanimously by the Parliament, which you can say that it is the expression or reflection of the collective will of the people, was thrown to the dustbin. That is something that was unfortunate. And this is also this I can say that was the zenith of judicial overreach. Our Vice President Dhankar, he was always advocating for the re-establishing of parliamentary supremacy. India is a country where there is no parliamentary supremacy, for the reason that we have evolved a new idea that our what is supreme is not parliamentary democracy, but constitution is supreme. Everything comes under the constitution. Constitution is subject to change when it is to the liking of certain people to bring out certain reforms. But reforms are coming from when reforms are coming from the legislature, and it is not to the liking of certain sections of the people. You will see that basic structure theory is being taken up, and with that basic structure, so the that legislation is uh, hacked with. That is what is happening. So, as part of this, when I wanted to say that these are all part of the present situation which is precipitated because of these developments of constitutional law with this judicial overreach and judicial activism. Judicial overreach, as I said, we have seen the zenith of it in this National Judicial Commission appointment case. 2015, after that, so many other cases also have come before the Supreme Court. The Citizenship Amendment Act, which has come, which also before this act taking birth, that was also challenged. A stay was also granted in that case. When we say that there is presumption of constitutionality in all cases, but when certain statutes are coming before it takes birth, with its commencement clause, with the notification, it is being unusually challenged and the stay is also granted, which goes against the axiom, in the legal axiom that there is presumption attached to constitutionality of a statute. We say that when a statute is made by the parliament, presumption of constitutionality is attached to it. But the Supreme Court says that in citizenship case comes, it says that we will adjudicate the matter for the present there is a stay. This is the way in which certain kinds of, I would say that certain kinds of adjudications are being taken by the Supreme Court. For the satisfaction of whom, I don't know. But the present act, which is posing a challenge, present act of the Supreme Court or adjudication of the Supreme Court on the Tamil Nadu bill case is something which we have to seriously take care of, and that has to be deliberated among the legal circles so that we can build up opinion against certain unhealthy, or I won't say unhealthy, but certain sort of adjudication which the Supreme Court is taking in certain matters. I can't be very specific and clear on this because I have to be very careful. That is why I am very, I can't, in other cases I would not have minced words. But in this kind of cases, we have to be very careful when dealing with the matters where we are commenting upon the adjudication process of Supreme Court or any other constitutional court or any court of law. Here, the Tamil Nadu bill case, Tamil Nadu bill case came up before a division by a bench consisting of 2 judges. When the matter was placed before the bench consisting of 2 judges, the 2 judges immediately assumed the jurisdiction under Article 32 of the Constitution and decided the matter in a very the way in which the adjudication was undertaken by the Supreme Court, that needs some good appreciation in the sense that when you take the decision as a whole, it is running to about 414 pages. We see that it's a scholarly decision, of course, there is no doubt at all. But I had certain doubts regarding the assumption of jurisdiction by the Supreme Court under Article 32 of the Constitution. You all know, Article 32 of the Constitution is exercised by the Supreme Court only only when there is a violation of fundamental rights. In cases where there is a violation of fundamental rights guaranteed under Part 3 of the Constitution, it is a litigant, a citizen, any person, a group of individuals can approach the Supreme Court for redressal of their grievances. That is the guarantee that is given by Part 3 of the Constitution, that is Article 32. Article 32 has got a different, Article 32 has a speciality for the reason that that itself is a fundamental right. When Article 32 itself is a fundamental right that is afforded guarantee to the citizens or persons or groups or denominations, then how a state government can approach the Supreme Court under Article 32 complaining that there is delay in the process of giving assent to the bills passed by the Parliament? Because state government is part of the state as is defined under Article 32 of the Constitution. Article 12 of the Constitution, Article 12 of the Constitution. State includes state legislature, state executive, union legislature, union executive, all other authorities under the control of the government of India, within the territory of India or under the control of government of India. So the state is an umbrella definition that is given under Article 12 of the Constitution. So a state government, like the state of Tamil Nadu, is also falling within the umbrella definition of state. State is the guarantor under Part 3 of the Constitution. State cannot complain about the violation of fundamental rights. Of course, the state can bring out certain cases like or some interpretation process where the state may say that not passed, the bill is not getting the assent, and the fundamental rights of the citizens are affected. So we are taking in the course for this the citizens of Tamil Nadu. It is not the case in the state of Tamil Nadu that they are litigating on behalf of the citizens of the state, the Tamil Nadu government. Rather, they would say that they straight away they approach the Supreme Court under Article 32 without any demonstration of fundamental rights of the state. Probably this may be, some may say that this may be a technical argument, but I could see that it's not a technical argument for the reason that Article 32 clearly says that for the violation of fundamental rights, you can approach the Supreme Court, which itself is a fundamental right that is guaranteed under Part 3 of the Constitution. And very specifically, you should also take note of Article 139 of the Constitution. Article 139 of the Constitution says, the Parliament by law empower the Supreme Court to issue writs in the nature of habeas corpus, certiorari, mandamus, etc., for any purpose other than Article 32. So, the Constitution is very specific when you read Article 32 in conjunction with Article 139. 1. That Supreme Court can exercise powers under Article 132. A party can, citizen can directly approach the Supreme Court under Article 32 for redressal of his grievances relating to violation of fundamental rights. That alone Article 32 says. So unless this Parliament makes a empowering the Supreme Court to adjudicate on other issues, there is no original jurisdiction conferred under Article 32. So invoking jurisdiction under Article 32, that according to me is a process. According to me, that is a complete deceptive approach to the state of Tamil Nadu, and by this deception played upon, the Supreme Court wrongly assumed the jurisdiction under Article 32. The deception is not that of the Supreme Court, but the deception is played by the Tamil Nadu, the state of Tamil Nadu. I don't know, very recently, for the last 5 or 6 years, we are seeing so many petitions under Article 32 of the Constitution are approaching the Supreme Court complaining about violation of fundamental rights, and some laws are also challenged. Even Citizenship Act, even Waqf Act, all these are challenged under Article 32, where individuals are also coming, individuals or groups are coming and complaining about their violation of fundamental rights. As far as this Waqf Act is concerned, they say that their religious freedom is breached with the enactment of Waqf Act. But when the Tamil Nadu bill case is concerned, the complaint to the state of Tamil Nadu was that there is a delay in the process of gubernatorial action of giving assent to the bills, and that has to be redressed, for which a timeline has to be set by the Supreme Court. That is the way in which the petition was drafted and was placed before the Supreme Court. The Supreme Court assumed jurisdiction under Article 32. According to me, this assumption of jurisdiction under Article 32 is a wrong exercise which needs to be corrected. Fortunately, I could see from newspaper reports that the presidential reference also refers to this aspect of the matter. Then, this is also an instance of judicial overreach. When there is a wrong assumption of jurisdiction for deciding certain issues enthusiastically, then we say that there is judicial overreach. This is an instance of judicial overreach. That is, assumption of jurisdiction itself is a wrong. I would say that itself is an overreach. That is an instance of overreach which happens at the beginning stage itself. Then takes the adjudication process. When you come to the adjudication process, when this matter comes before the courts, Article 145, 3 of the Constitution says that all matters pertaining to the interpretation of the Constitution shall be heard by a Constitution bench. The Constitution bench is comprised of not less than 5 judges. This was initially fixed. When the Constitution came into force, the initial number of the Constitution, the framers of the Constitution fixed 5 as the minimum number of judges required for deciding constitutional issues, when the total strength of the Supreme Court was 7. So 5 is to 7. I would say that 5 to 7. Now, the total number of judges in the Supreme Court, including the Chief Justice, is 34. If we count this proportion, when it is worked out, then you will see that a minimum of 20 to 23 judges are to sit for hearing constitutional matters. But Constitution itself was later amended, which says that the minimum required strength of the Constitution bench is 5. So with this 5, they could have undertaken the adjudication process. The adjudication process that is carried out by the Supreme Court in this case is also apparently against the constitutional mandate under Article 145(3). So you see the characteristics of judicial overreach. First, assumption of jurisdiction itself is wrong. Secondly, the adjudication process itself is wrong. Then, thirdly, when you take the interpretation clauses, Article 200 and 201 were subject to interpretation by the Supreme Court. Article 200 and 201 were relating to, that is relating to the governor's assent bills. When you read Article 200 and 201, you see a timeline there. That timeline is only with regard to the reconsideration of bill by the legislature after it being sent by the president with his or her comments. So the process, the bill is passed and sent to the governor. Governor can give assent, or governor can send it back with his own comments with the amendments which he is proposing. The other option of the governor is that when it is offending the legislative powers are distributed, or the barriers or the limits of legislative powers of state and then if the governor sees apparent conflict with a central law that is covering the subject, the governor can restore the bill for the consideration of the president. And also, when a legislation is passed by the state legislature, which is trying to undermine the jurisdiction of the respective high court of that court of that state, then also governor can be sent to the president. It can be reserved for the assent of the governor. The president. These are the two events wherein the governor can go for reserving the bill for the assent of the president. The president can take a decision upon this. When the president is considering this bill, president sees that some amendments are also necessary. Some comments are with those comments. The bill is sent back to the state legislature, to the governor. Then, when the governor receives it, the legislature, which is called upon to decide on the comments and amendments proposed by the president, it has to decide it within 6 months. So, when take the two articles, Article 202 and 201, then you see a time limit there that is expressly fixed. But as far as assent is concerned, Article says only as soon as possible. When the framers of the Constitution, when they were deliberating the draft Article 175, this issue actually was not under the consideration of the setting of time limit was not seriously deliberated in the Constituent Assembly. But one member from the Bihar province, he said that the governor should be given absolute discretion in giving assent or not. And he says that by taking into account the trends which were prevailing in the provincial assemblies, that is, the provincial assemblies were making laws apparently inconsistent with the other, the union laws, of that is the British laws. So the disruptive legislations are likely to emerge from state legislatures. When disruptive legislations are coming from the state legislatures, the governor should be given absolute freedom for refusing assent. Absolute freedom must be given, but that is not accepted. Anyway, we have to accept one fact that the governor has no absolute discretion in disregarding the mandate of the people. But when the Constituent Assembly did not prescribe a time limit for the governor to take a call on the assent bill, it was improper for the intervene and set a time limit to by exercise of powers under Article 142 of the Constitution. So this also you could see that for setting the time limits, which is not originally in the Constitution, the Supreme Court is overreaching. Supreme Court is overreaching in the sense that, which I have already said, assumption of jurisdiction, adjudication, and now in the interpretation process also. Of course, we could have understood if this exercise of interpretation was taken by a constitution bench, but it was not taken by a constitution bench. Because when the constitution bench is sitting, when it was originally fixed as 5, when the total number was 7, the framers of the constitution wanted to give weight, quality, and quantitative wisdom for the interpretation of the Constitution. So when more persons are sitting, number of persons sitting also matters. When a stormy session takes place with the multiple number of people, they are sitting on the bench, then the due deliberation takes place. And with the due deliberation, a decision is taken or interpretation is given, it gains some sort of a legitimacy for the adjudication process. That is why in the Constitution, very consciously, the framers of the constitution said that when you undertake the exercise of interpretation of constitution, it has to be done by a constitution bench. We have seen in yesterday's constitution benches, which the Shankari Prasad case, which I have already mentioned, that is 5 judges sat together when the total number was 7. Then the IC Golaknath case, 11 judges. Then came the Keshavananda Bharati case, 13 judges. Indrajani case, that is Mandal Commission case. I think that was more than 10. So when important issues are called upon to be adjudicated by the Supreme Court, the Constitution Bench ought to have been constituted, and the Constitution Bench ought to have decided this issue. So in that respect, I can't say that the judges who decided this issue was ignorant of the Constitution provision, that is Article 145(3). Still, what prompted the judges to take a decision and go for an interpretation of the Constitution with these 2 judges on the bench, which I am very surprised. I can't ascribe ignorance to the judges, and because they were also seeing the development of constitutional history and the interpretations which were given by the Supreme Court and the Constitution Bench on important constitutional matters. Anyway, this is something that is within the knowledge of each and any man, that this is something that is relating to the interpretation of Constitution. When you set a timeline, that is going to introduce a new thing into the Constitution. It is not simply an interpretation, but it takes the shape of an interpolation. So that the court should have been more vigilant, and propriety demanded that the matter ought to have been referred to the Constitution Bench. Then finally the relief portion. You see the relief portion, how the relief has been granted. For the purpose of granting relief, Article 142 had been was used. Article 142 was used. Article 142 now has become, that's why Vice President Thankar, he says that Article 142 is now being used as a missile. That is what the expression which he used. Article 142, you see, it's for doing complete justice. The Supreme Court, when I went through the terms which were used, the semantics would denote that this is something that is given to the Supreme Court for doing complete justice in individual cases and adjudications. Because when we trace the history of Article 142, in the Constituent Assembly, this was adopted without any discussion or deliberation at all, because that is something that is prevalent therein under the Government of India Act 1935. Because this power was there with the federal court. The power was given to the federal court to do complete justice. In federal courts, there were no adjudication constitutional matters, even public policy matters. All these matters which were dealt with the federal court were all individual cases, private litigation. When private litigations are taken to the federal courts, I think that many persons who are sitting in the civil side, you will see that instead of Privy Council, this federal court was established in India under the 1935 Act. Before that, prior to that, we had to file appeals before the Privy Council at London. Now, with the Act, Government of India Act, the federal courts came into force. In the federal court, this power, for the federal court, Government of India Act conferred this power for doing complete justice, which was adopted in the present constitution. That is a verbatim reproduction of the Government of India Act, as far as the power to do complete justice is concerned. See, in earlier days, when we analyze the constitutional history, when you go for a survey of the constitutional, the adjudications on the constitutional side, you could see very rare invocation of this power under Article 142. And when Article 142 was invoked in a case where the order passed under 142 had the effect of curtailing the fundamental rights, the matter came up before the constitutional bench in Premchand Garg case, where the Supreme Court said that Article 142 you can't simply use it, and you can't use it for the purpose of abridging the fundamental rights of citizens. So that was the very, very rare exercise of jurisdiction under Article 142. We could see in the constitutional history in the early evolving period of our constitutional jurisprudence. But what I wanted to say is that when you take the civil procedure code, you will see powers to the appellate court for molding the relief. I think it is Order 21, Order 41, Rule 33. Order 41, Rule 33. You know, but Rule 33. Rule 33. So that is the power when an adjudication on the appellate side comes, the High Court or the appellate court for that any matter, the district court, can exercise its powers for molding the relief, for doing complete justice. On the criminal side also you could see 482 now it is 528, and also there is another provision in the earlier repealed criminal PC, that is a proviso, I think, that is added to section 386, which says that the appellate court has powers for passing supplemental orders for doing justice. So appellate courts were conferred with powers for exercise of its discretionary jurisdiction for the purpose of holding reliefs. I think that when I read Article 142 and its history, I could find that this was the reason why Article 142 was there. When the Supreme Court was called upon to adjudicate on the appellate side private litigations, to pass orders for doing complete justice between parties. We often see in matrimonial jurisdictions, the Supreme Court is exercising this power under 42 for dispensing with the waiting period, etc., etc. When the parties, after a long drawn litigation, approach to the Supreme Court, and they say ultimately before the Supreme Court that we have compromised the matter, we are filing a petition for a divorce on mutual consent. Supreme Court was exercising this power under Article 142 graciously. That was on the civic side. So private litigations. So for doing complete justice, would be involved on private litigations, no doubt at all. But as I earlier said, the Supreme Court was exercising this power for laying down judicial directives in the form of judicial legislations. You see the Vaisaga case also, DK Basu case. But these cases, when, as I said earlier, these cases were decided or the general guidelines were coming from the Supreme Court when the executive becomes free. To relate this with the events which were taking on this political spectrum at that point of time, we will see that these directions are coming. Exercise of 142 for the purpose of judicial legislation are coming when the executive becomes free. In this Tamil Nadu case, without much deliberation, Article 142 was exercised by the Supreme Court. But months before the decision in the Tamil Nadu case, the Supreme Court was called upon to examine the correctness of the decision in Asian Surfacing Company, wherein the Supreme Court has set a timeline for disposal of lower court matters where stay is granted by the High Court in exercise of its supervisory powers. The High Court is exercising its powers, supervisory powers under Article 227, and is granting stay, attending stay, and it was the matter get protracted in the trial court. Supreme Court took note of this matter in the Asian Surfacing Company case and said that after 6 months, the stay will automatically expire if the High Court is not exercising its supervisory jurisdiction and adjudicating the matter, and the stay comes to an end in all cases. A blanket direction was given in civil and criminal cases, where the Supreme Court says that if the High Courts in India had issued the interim direction staying trial or other proceedings in the trial court. And if it is going beyond 6 months, there is automatic vacation of stay. The trial court can proceed with matter. So that blanket exercise of jurisdiction under 142 was again doubted, and the matter was sent to a constitution bench. And that constitution bench decided the exercise of power under Article 142 under what, in what circumstance, what are the parameters for the exercise of power under Article 142. The Supreme Court in Allahabad High Court Bar Association case said that we can't fix a time limit under Article 142 of the Constitution. We can't fix a time limit under 142 of the Constitution because that's a constitutional court or a trial court. The trial court and the constitutional courts only know the pendants of cases there. There cannot be a blanket direction fixing a timeline for deciding cases. I think that the same proposition would squarely applicable to the case of Tamil Nadu bill. When the constitutional courts or the trial courts could not be issued with any direction that they have to dispose of case within timelines, how could the president be directed to you decide the matter within 3 months or there will be deemed assent? The deemed assent, you can see the deemed assent is the death knell of actually the constitutional democracy in India. You see the president, how the president is elected. I think that is the most democratic way. The president of India is elected by an electoral college consisting of the members of the parliament and also various the members of the legislatures. It is not by the number the majority is decided. It is by the value added to each vote of the members of the legislature and also members of the parliament. So where what counts is the population also. The value of the vote of an MLA of Manipur is not the vote of the MLA of Kerala because the Kerala MLA, he represents a constituency where the population is more than 3 lakhs or 2.5 to 3 lakhs. Whereas the Manipur MLA represents a constituency where there may be only 25,000 people. So same value cannot be given. So value calibration process in the constitution when we go for the election of the President of India. Different values are given to the votes of the MLAs of different states. That is to ensure maximum perfect democracy. Our President of India is elected by the nation itself. That is a reflection of the nation. The will of the people is reflected. That even you see the Prime Minister is elected by the legislative party. If the legislative party enjoys majority in the lower house, he need not have majority in the upper house. For the Prime Minister, but for the President, the perfect democratic process our Constitution undertakes, that is for vesting the President with the supreme command of the defense. Supreme command of the defense is protecting the sovereignty of India. So the protector of the sovereignty of India is the President of India. The President of India is directed under Article 142 to take a decision within a particular timeline, which is actually undermine the democratic process and the constitutional democracy which is envisioned in our constitution. So these are the incidents which I have already mentioned. When we take this decision is a classic example of judicial overreach. Because assumption of jurisdiction, adjudication process, interpretation, and the granting of relief. All these portions, you could see that very weird adjudicatory process was undertaken by the Supreme Court. In this respect, also I should mention about one decision of the Constitutional Bench I think that Ramachandra Murthy case, I think. Ramachandra Rao case. That is also on similar fashion like this uh, Asian Surprising Committee case. You know the Rajdev Sharma case and the Common Cause case. This was something that is rendered in 2000. So Rajdev Sharma case and Common Cause case. What mattered there was also delay. If under trial prisoners are there without bail and they have suffered imprisonment more than what is the maximum that is fixed, not half, more than half of what is fixed for that particular offence, they must be released. That is Sharma case. Then certain other directions that is also time related. If some proceedings are not completed, criminal proceedings are not completed within a particular time frame, all must be acquitted. So these are the two sets of cases, Rajdev Sharma case and common cause case. Based on common cause case, a man who was accused in the Prevention of Corruption Act was acquitted by the trial court, which was challenged before the Karnataka High Court. Karnataka High Court also upheld, going by the common cause case. The Karnataka state went in appeal before the Supreme Court. The Supreme Court constituted a constitutional bench for deciding whether a timeline can be fixed. The Supreme Court undoubtedly said that no timeline can be fixed for the purpose of taking decision by the courts. Of course, it is true that speedy trial is something that is guaranteed under Article 21 of the Constitution, but based on which you cannot come to a blanket conclusion that a person who is suffering who is facing a prosecution has to be discharged or acquitted when a particular time frame lapses. The Supreme Court in that decision actually quoted a monograph of Wade. We all say about Wade. His book is The Judicial Activism in India and Constitutional Democracy. He laments the adjudication process which were in those days, that is in the 80s or 90s, undertaken by the Supreme Court and other constitutional courts. And he says that this is nothing but overreach. And also S.P. Sathe, we have studied books written by S.P. Sathe, Administrative Law. Administrative Law, it's a very classic book, that is Administrative Law, that is written by S.P. Sathe. He authored that book. S.P. Sathe also had written an article or book on this subject, judicial activism. That is also quoted in the decision, Ramachandra Rao case that was decided in 2002. So our Supreme Court is also conscious, even the Constitution bench of the Supreme Court is conscious about the fact that some decisions, some adjudications it had undertaken some decisions are reflecting judicial overreach. Though it is undertaken in the name of judicial activism, which I have already in the commencement at the inception itself I said, judicial activism is something that is permissible. You are interpreting constitution, interpreting various provisions for doing justice to the parties. But for judicial overreach, you wrongly assume jurisdiction. You take that I am the person here to sit. I am the person here to sit and decide the matter. I will encroach upon the domains that were set apart for the judicial, for the executive and the legislature. I will make the laws. I will make use of certain provisions of the Constitution for judicial legislation. Then we say that it is judicial overreach. And coming to the federation, I would say that what is being always made use of by the Supreme Court is the basic structure theory. Basic structure theory is something that is invented and propagated by one German philosopher, Conrad, while he was delivering a lecture in Banaras Hindu University, which was quoted by M.K. Nambiar in, I think that A.K. Gopalan case or some case. Later it was developed But this basic structure, doctrine, which says that Parliament is the creation of the Constitution. So, Parliament can make laws without touching, without shaking the pillars of the Constitution. And the Constitution is supreme and not the Parliament. Our Vice President is advocating for parliamentary supremacy. My understanding of the Constitution, when I read the preamble to the Constitution, I could see we, the people of India, having solemnly resolved to constitute India in a sovereign, socialist, secular, democratic republic, and secure to all its citizens justice, social, economic, political, liberty of thought, expression, belief, faith, and worship, equality of status and of opportunity, and to promote among them all fraternity, assuring the dignity of the individual and the unity and integrity of this nation. Then, that's the most important. We, the people of India, on this 26th day of November 1949, do hereby adopt and give to ourselves this Constitution. I say, with all respect, I disagree with the Supreme Court that it's not the Constitution, but the people of India are supreme, which is reflected by way of the will of the people in the Parliament.
What's the remedy if timelines are not complied with by the governor or?
That is also yet another issue. Because when you go by Article 361 of the Constitution, governors 361, I think 361 or 363, I don't know, 361. The governors and president are given absolute immunity from the judicial proceeding. How can they be held in contempt? I don't know. This also is a fact which I should have also dealt with when I delivered this presentation. Because state of Tamil Nadu versus governor, how could such a petition be maintainable if we go by the strict constitutional dictates and mandates? Because governor cannot be made a party in judicial proceedings. That fact, how it was addressed, I couldn't see it from this 414 pages judgment. I think that the presidential reference is also this aspect, the immunity that is given to the president and the governor. Situations may arise. I came across one judgment of Allahabad High Court which was delivered in 1962. There was a tussle between the legislature and the one man was convicted by the legislature for a breach of privileges, etc. And he was sent to prison. A repetition was moved before the Supreme Court, Allahabad High Court. Two judges ordered his release. Immediately, the Speaker of the UP Assembly, he convened a meeting, and after deliberations, he issued arrest warrants against the judges. The entire court, I think the entire Allahabad High Court, sat together. A bench was constituted comprising of 23 judges, and that case was decided. What happened to the case, I couldn't find out the outcome of the case, but just I read it in the Wikipedia, that's all.
Sir, you told about the Common Cause case and Dastia Sharma's case. With regard to, in that case, the Common Cause case, it was decided that when a process is started by the criminal court, and after some time, after to a certain extent of time, it was not done, the accused could have been acquitted. That is what the Common Cause says. Just like that, this Supreme Court, with regard to this Waqf Act, 1935, with regard to the 1935 Act, an amendment, Section 40, challenging Section 40, that was filed challenging Section 14. Petition under Section 32 was filed before the Supreme Court. Supreme Court has done nothing in that case, and now it is came up for hearing. What is the corruption? It is said that if you are doing a thing which ought not have been done, it is corruption. If you are not doing a thing which you should have done, must be that is also corruption. Just like that, is it amounts to judicial corruption? They are not.
Must be very circumspect in commenting upon. We have our own reasons for keeping restraint. So I can't say anything upon that. You also know we will talk in private. Clarifications. I think that I tried my level best to present certain points. If you are able to, if you want to have some clarifications on issues, I will try to address and then try to answer. It's very late in the day. Huh?
Tamil Nadu bills case, judicial activism or judicial overreach insightful class senior advocate S. Anakumar Sarna, Bharatiya Abhibhasha Varshat, High Court പേരിലും എൻ്റെ വ്യക്തിപരമായ പേരിലും നന്ദി അറിയിക്കുന്നു. ഇവിടെ എത്തിച്ചേർന്നിട്ടുള്ള എൻ്റെ നന്ദി അറിയിക്കുന്നു.